Hello. Welcome to this week's Private Funds Update. I'm Sandra from SmartEsq. Here's what I learned this week. We're starting with a significant compliance milestone on the West Coast. We've touched on California's Fair Investment Practices by Venture Capital Companies law before, but as we hit the final stretch of February, it's worth a comprehensive look at the roadmap ahead. The goal here is transparency in the venture ecosystem, and the rollout happens in two key phases. First, there is a March 1st registration deadline. If your firm has a California nexus, meaning you're headquartered there, have a significant office presence, or even just a healthy volume of California-based investments or LPs, you'll need to register as a covered entity with the Department of Financial Protection and Innovation. The second milestone is April 1st, which is the deadline to submit your first annual report. This report will aggregate anonymized demographic data from the founding teams of companies you invested in during 2025. It's important to note that founder participation is entirely voluntary, and the DFPI has even built in a 60-day cure period for those who might need a little extra time to get their systems in order. It's a new process for everyone. So the focus right now is simply on getting your data collection pipes connected before that April window. Moving to the federal regulatory front, the SEC's enforcement director recently gave her first major public remarks. Instead of the usual tough cop rhetoric, the director's remarks signaled a pivot toward due process, specifically aiming to pull back the curtain on the Wells process. Historically, receiving a Wells notice could feel like a black box experience, but the director outlined several key improvements to make it more of a two-way street. First, the staff is being encouraged to be more transparent about their legal theories and evidence much earlier in the investigation. We're also seeing a commitment to more detailed Wells notices, moving away from boilerplate language so firms actually know the specific charges they are defending against. Perhaps most significantly, the director suggested that defense counsel may get earlier access to key evidence or unfiltered facts before they even submit their response. The goal is to foster a more substantive dialogue and ensure the commission has a complete picture before making an enforcement recommendation. It's a move toward proactive compliance over regulation by surprise. Staying with the SEC, the Division of Investment Management just dropped a fresh batch of FAQs regarding the NAMES rule. We're looking at the 2026 implementation window for these updates, and the SEC is getting granular. The guidance focuses heavily on the mechanics of compliance for the 80% investment policy requirement. For instance, the SEC clarified how to treat derivatives when calculating the 80% threshold, emphasizing that funds should generally use notional amounts rather than market value to ensure the name accurately reflects the fund's economic exposure. The staff also addressed unplanned departures from the 80% requirement, such as those caused by market fluctuations or large redemptions, outlining specific timeframes for returning to compliance. For private fund managers, the key takeaway is a focus on consistency. If a fund name suggests a specific investment type or geographic focus, the internal compliance monitoring must be robust enough to track that 80% allocation on a continuous basis. Finally, let's look at the evolving legal landscape for GP-led continuation vehicle transactions. Recent litigation in the Delaware Chancery Court has reinforced that when a GP sits on both sides of the deal, the transaction is often subject to the entire fairness standard of review. This means that the governance provisions in your LPA regarding continuation funds need to be highly specific. It is no longer considered sufficient to rely on broad, general conflict of interest waivers. Instead, best practices for LPA drafting now favor clearly defined procedural safeguards. These may include hardwiring the requirement for LPAC approval with full transparency on valuation, as well as explicitly providing a status quo option that allows LPs to exit at a fair value if they chose not to roll over into the continuation vehicle. By incorporating these structural protections, GPs can better demonstrate that the transaction process was designed to be arm's length and fair to all parties involved, mitigating the risk of later challenges in court. That's it for this week. You can learn more about these topics from me on the SmartEsq platform. If you are curious about the services we offer, please visit www.smartesk.ai.